Hi guys, it's Kathy. I hope you're doing well. So, I start us off right where we left off yesterday, except I rewound it. I rewound it. I rewound it. Um, couple minutes, like 1 minute, less than 1 minute, I hope, so that it's called foreplay. We get right back into where we left off. We don't just jump right into it. We prepare ourselves to what's about to happen. Junkin, you're number one. Number one. Look at this. They look so smug. Look how smug they look. No, it's 22-4-19, Fozzie. You're backwards. And there should be a U in there somewhere. Alright. I'm not in the mood for him smugness today. Here we go.
You didn't go look to see where this might have taken place, did you?
No.
You talked to Mr. O.J. Simpson, and he told you, according to your statement, that he had pushed her out of his bed. Is that correct?
That's correct.
But he hadn't beat her, right?
That's correct.
And then based upon that, you then decided you were going to place him under arrest, right?
No.
Well, you then made a decision while you're outside this gate to place Mr. O.J. Simpson under arrest. Isn't that correct?
That's correct.
And is there anybody else around there that you talked to?
I talked to Nicole Simpson, and I saw her.
All right, you saw Nicole Simpson. You know, do you not, sir, that if somebody gets into a fight, on occasion there may be bruises on both sides. You understand that, don't you, Mr.
Oh, yes.
Police officer?
Yes.
So you talked to Nicole Simpson, you talked to O.J. Simpson, but you had made your decision, had you not, before you talked to O.J. Simpson, isn't that right?
Yes.
You made your decision after only talking with Nicole Simpson, isn't that right?
That's correct.
And you didn't talk to anybody else in connection with that decision.
Didn't talk to anybody else.
And at that time, how long had you been a police officer?
About 19 and a half years.
And had you worked as a detective at that time?
No.
You become a detective since that time?
Yes.
Were you a patrolman at that time?
Yes.
You've been 19 years on patrol?
Yes.
I have nothing further at this point, Your Honor.
Thank you.
You spoke to Nicole Brown and then you arrested the defendant. Is that correct?
I placed him under arrest. Physically, I couldn't get to him.
Okay. And what was the basis of your decision to arrest him?
Her statement of how she was injured and that I could see trauma on her.
Did the LAPD have a policy regarding spousal battery cases?
Yes.
And that policy related to when to arrest a suspected wife beater, is that correct?
Sustain. Rephrase the question, please. Rephrase the question, please.
You've read the law regarding spousal abuse, is that correct?
Yes.
And were you aware of the law as it stood in 1989?
Yes.
What duty, if any, under the law, did you have to arrest this defendant on January 1, 1989?
Overruled.
Under 273.5 of the Penal Code and 13-700 of the Penal Code, I shall arrest that person. There's no ifs, ands, or buts about it, wills or mays. I shall arrest the defendant.
You're required under the law, under these circumstances, to arrest.
Under the Penal Code and my department policy, absolutely, I have to arrest that person.
You told Mr. Cochran a moment ago that you did not examine the defendant up close. Is that right?
Just within about a foot with a fence between us.
Had he not run away, would you have had an opportunity to examine him?
Overruled. You can answer the question.
So he says wife beater. Objection. He says he ran away. Objection. Dude, this all just happened. It's facts. Let it go.
Yes, I would have had a chance to examine him thoroughly had he not fled the scene.
That was a few questions.
sir.
That was a few questions.
And legalese, if you was like 10 or 15, Your Honor. But finally, did he complain to you or show you any injuries?
May I ask an
Last question.
No, it was a different question. Slightly different question.
Did he complain to you or show you any injuries?
No, he did not.
Thank you. That's all I have.
Mr. Cochran.
Well, once you made your decision to arrest Mr. O.J. Simpson, you didn't ask him about any injuries anyway, did you? You just wanted to take him to jail, isn't that right, sir?
Absolutely.
That's the situation. You weren't interested in his welfare at that point, isn't that correct?
I could see he was not injured.
You couldn't see it. Let's strike that. You had made a decision, and that's what you're going to carry out. Isn't that right, officer?
Under the penal code and department policy, he was going to jail for 273.5.
Right. And as you said, if the other officers had been out there 7 or 8 times, would under that same law that you're under, right, that you were under on January 1st?
Exactly.
That would mean that since he wasn't arrested, nothing happened like that. Isn't that correct? That was the law. Isn't that correct?
Not necessarily.
Not necessarily. But you don't know, do you?
I don't know, neither do you.
You didn't bother checking, did you?
No.
You thought the sergeant would check that, didn't you?
I thought the sergeant or the detective that was handling the case would check that, yes.
You don't know whether or not they checked that or not, do you?
As far as I know, I don't know.
All right. Detective, thank you very much. You're excused. Please don't discuss your testimony with any other witnesses. Mr. Darden, your next witness, please.
Your Honor, I have in my hand what appears to be the LAPD policy as it related to spousal abuse. It is a policy that was in effect on January 1, 1989. May it be marked People 6 for identification.
People 6.
I have a moment to check.
Please. All right, Mrs. Robertson.
You do solemnly swear that the testimony you may give in the cause now pleading before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I so do swear.
Please be seated and state and spell your first and last name for the record.
Mike Farrell, MikeFarrell.
Mr. Darden.
Sir, were you a police officer employed by the LAPD on January 3, 1989?
Yes, I was.
And what was your assignment at that time?
I was assigned to West LA Detectives, assigned to the Crimes Against Persons detail.
And did the crimes against person detail include spousal battery cases?
Yes, they did.
Did you respond to 360 North Rockingham on the morning of January 1, 1989?
No, I did not.
You were not a patrol officer at that time?
That is not, I was not a patrol officer, no.
And on January 3, 1989, were you assigned a case involving Nicole Brown and this defendant?
Yes, I was.
And who assigned you that case, if you recall?
My supervisor was Detective Sergeant Glenn Varner.
And what is a normal procedure for a detective in West LA Division after a case is assigned to them?
Well, this case, after it was assigned to me, my supervisor explained to me what I should do with it and adjudicate it as soon as possible by interviewing the victim and the defendant, if possible.
And did you interview the defendant?
Yes, I did.
Did you interview him in person?
No, I did not. I interviewed him over the telephone.
Do you recall who called who?
Yes, I phoned the residence.
And how many times did you phone the residence before you finally spoke to the defendant?
Once, I believe I called on the 3rd in the later morning before the afternoon.
Okay. Had someone already prearranged a time when the two of you would speak?
Not that I recall, I just made my phone call.
Okay. And he picked up the telephone?
Yes, Nicole Simpson picked up the phone.
And did you next speak to the defendant?
After I spoke with Nicole, yes, I did.
Okay. And did you recognize the defendant's voice?
Yes, I did.
Was it a voice you'd heard before?
Yes,
And where had you heard the defendant's voice before?
numerous times on television.
And did you ask the defendant about the occurrences of January 1, 1989?
Yes, I did.
And what did he say?
He explained to me that after he and Nicole returned home after a New Year's Eve party, that they were ready to, they were in their bedroom and a verbal dispute broke out between them. And that the dispute got out of hand and it became physical. He told me that it turned into a mutual type wrestling match. And that was basically it, nothing more than that.
Did you ask the defendant about the injuries Nicole Brown sustained?
Yeah, I asked him about because I had a photograph that showed injury to her forehead, and I told him that I looked at a photograph that depicted some injury to Nicole's forehead, and he said, well, I know, I was surprised to even see that even occurred because of the incident.
Did he deny causing those injuries?
No, he did not.
Did he admit causing those injuries?
Yes, he did.
You asked the defendant about the 911 call to police.
No, I don't think I asked him anything about the phone call itself, no.
Okay, so basically then all you asked him was what happened.
That's correct.
Now, after receiving this information from the defendant, did you write a report?
Yes, I did.
And did you include in that report the information the defendant gave you?
Yes, I did.
Did you continue to investigate the matter?
Yes, I did. I asked, after I did the initial telephone interview with the defendant, Nicole, I told Nicole that I would like to see her in person if she can make arrangements to come to the police station. She agreed, and she would come down the next day. She would also bring her 2 kids with her, and she did come down and meet me.
And so you did meet Nicole Brown?
Yes, I did.
What day was that?
I believe that was the 4th of January, the next day.
And what injuries, if any, did you notice on her face and neck and head area at that time?
I just noticed some bruising on her forehead. That was all.
And did you re-interview her?
Yeah, I explained to her what was going to happen in this case, and I explained to her the procedures that would happen. I reviewed the original police report with her and asked her to review it. We reviewed it together. I asked her, does this accurately depict what happened over the weekend? She said yes. I said, is this your signature on the report? She said, yes, it is. And then I explained that I would be preparing the case for a prosecuting attorney.
Did you refer the case to the LA City Attorney's Office?
Yes, I did.
And do they have a special unit that handles cases like these?
I believe they do. I met with the supervising attorney there and provided her with the information.
And what was the supervising attorney's name?
Mary Claire Molador.
You gave Deputy City Attorney Molador all the reports?
That is correct.
Did you show her the photographs?
Yes, I did.
How do we spell Molador?
I believe it's Molidor.
Do you recall the date in which you turned over your case file to the city attorney's office?
I believe it may have been the afternoon of the 4th or the morning of the 5th. I do not recall the exact time.
And after you referred the matter over to the city attorney's office, did you again speak with the defendant?
Yes, I did. He phoned me at my desk early in the afternoon. I believe it was after lunch.
Was the case against the defendant filed?
Yes, it was.
What was filed?
One count of spousal battery. I believe it's 273A of the Penal Code. I'm not exactly sure. Sure.
When you spoke to the defendant on the telephone, January 5, that call was January 5, correct?
That is correct.
Okay. When you spoke to him on the telephone on January 5, what did he say?
Well, Mr. Simpson phoned me, and he was inquiring about what this case status with his incident was. I explained to him that I had turned over the entire case file to the city attorney's office, and a decision had not yet been made. And the defendant and I did have a conversation. He discussed with me his feelings about the matter. He wanted to relay to me that he was sorry that the police had to come to his residence, and that me, as a detective, had to get involved in his personal problems. And he was really remorseful about what happened that day, and that he and Nicole were going to seek counseling to resolve their family problems, and that if I could relay that to the city attorney when they make their final decision in filing the case. I told Mr. Simpson I would do that, but I also told Mr. Simpson that it's most likely he is looking at filing for a criminal charge, and that he did one day have to face up to what happened and would have to answer for it.
Do you recall him saying anything else?
No, it was actually a pleasant conversation. I don't recall anything else.
Okay. Did you write a report in this matter?
Yes, I did.
I have a report here, Your Honor. It's dated February 8, 1989.
Report February 8th,
Yes.
89.
And before I proceed with the report, Detective, did the defendant describe for you or mention to you how Nicole Brown sustained the injuries she sustained?
Again, he explained that it was a result of an argument that they'd gotten into that resulted in a physical altercation, more of a mutual type wrestling match. Nothing else.
Do you recall everything that was said in the conversation?
That's most that I recall. If I have anything else, I could refer to the report.
Would that refresh your recollection?
Yes.
May I, Your Honor?
You bet.
I'd like to show the witness the report dated February 8, 1989. Mr. Courtroom has a copy.
All right, Detective, you can just read that to yourself, please.
Have you read the report, Detective?
Yes.
Does it refresh your recollection?
Yes, it does.
What else did the defendant say?
He told me that he was sorry for what he did to Nicole, and that he didn't mean to harm her in any way, and that he would seek counseling with her.
Didn't he also tell you that he knew that what he did was wrong?
Yes, he did.
Isn't that what you wrote in your report?
Yes, I did.
And when he told you that he didn't mean to harm his wife, did he elaborate on that at all?
Not that I recall.
He didn't describe the incident as a mutual wrestling match in this January 5 conversation, did he?
No, he did not.
Did he ask you not to file a
He asked me to relay his feelings about the whole matter to the city attorney's office.
Did you do that?
Yes, I did.
The report that you just read, dated February 8, 1989, that report wasn't in existence when you referred the matter to the city attorney's office. Is that correct?
No, I maybe have to make something clear on the report. It's dated 2/8/89. That may be a typographical error. The case was filed on January the 30th, 1989. And I may have typed the statement that he gave me that same day, and I may have put the wrong date on there. It should be, I believe it's 1/8/89.
Okay, but he did apologize for his conduct.
Yes, he did. He was very cordial about it.
Now, after you referred the matter to the city attorney's office, did they give you any further directions?
Yes, after some time, they asked me to look into the other incidents that were described by Nicole. She apparently told the officers who responded to her home that the police had been out there on numerous other times, and they asked me to look into that situation.
And did you look into that situation?
Yes, I did.
Did you determine that there were other situations or occasions when LAPD officers went to 360 North Rockingham?
Yes, I did. I inquired with some of the more senior officers at West LA that had been working the division for over the last 5 years and asked.
I'd like to object. It's not totally responsible. Required to make him be here, so I'm not sure the response.
Sustained.
Okay, well, what action, I'm sorry.
Question just a little overbroad.
What action, if any, did you take to determine whether or not other police units or officers had gone to Rockingham?
I spoke with senior officers at West LA and asked them if they had ever been to the location on Rockingham in the past.
All right, Mr. Darden, I take it you're about to launch into another line of inquiry at this point?
Do anything else?
Excuse me, Mr. Darden?
Yes.
I take it you're about to launch into another line of inquiry at this point?
Yes.
All right, we're going to take our afternoon recess, and at this point, if you recall our schedule for times, we actually get started at 1:30. We're going to take our break at 2:45 because it takes the sheriff half an hour to cycle the jurors. All right, ladies and gentlemen, we're going to take our afternoon recess for this afternoon. We'll resume at 15 minutes after 3. Please remember my admonition to you. Don't discuss the case amongst yourselves, form any opinions, have any contact with anybody, or conduct any deliberations, and we'll see you back here at 3:15. All right, we're in recess. All right, Mr. Douglas said he wanted to address something.
We started out, except we had no.
Well, makes the argument shorter.
A lot easier. Why don't you start now? And you can rule right away, Your Honor. It'll be less vitriolic.
Oh, I don't know about that. These elevators are a travesty in this building. He asked.
We need a special object for film and props.
Miss Abramson, what a delight. What a delight.
I guess cross-examination.
Could you please take your tongue out of your cheek?
I mean it sincerely. I almost miss you.
Almost, yes, I've been watching. I can imagine that you almost miss me, but are reminded of you.
Yes. All right, we've been rejoined by our prosecutors. All right, Mr. Douglas, you had something you wanted to bring the court's attention before we invite the jury to join us?
I did, Your Honor. There was a letter that was transmitted to the court and a copy given to counsel concerning our supreme interest in quickly examining items of physical evidence. As the court is aware, the people have apparently now concluded their testing on items of evidence. There have been discussions from Mr. Blazier, Mr. Scheck, along with Mr. Clark and Mr. Harmon, and there has been an agreement that the items may be shipped to the forensics laboratory in Albany, New York, of Dr. Barbara Wolf, one of our doctors. We have not, in earlier occasions, had a chance to physically touch any of the items of evidence, any of the serological evidence, mind you. We had not had a chance to take our own pictures. We were hoping that this can be done soon, and we were seeking to introduce the protocol consistent with that which was used with Cellmark, so that they would be allowed to have a representative present for a chain of custody matters. They would be allowed to observe the cutting or the splitting of any samples. However, they would not be allowed to watch the actual testing so that we can maintain the integrity of our testing methodologies. I wanted to try to get some sort of closure on this issue so that we may quickly be able to get the items taken back, tested, and then returned before they'd be used in this actual trial. Given that we are currently on the domestic discord aspect of the trial, where the physical evidence is less probative or even necessary, I was hopeful that I could fashion some resolution today so that we could have those items sent out in the coming days.
Ms. Clark?
Yes.
I did receive a photocopy of the fax letter, and I don't recall, however, that was early in the morning as we were trying to deal with other matters. Ms. Clark?
Yes, Your Honor. I spoke to Mr. Douglas this afternoon, and he informed me at 2:45 that he wanted to address this matter at 3:15. I called upstairs to find out if I could get Rock and Woody here because they did have very specific requests about the procedures that they wanted to have employed. Unfortunately, they are at SID. They will not be able to make it until tomorrow. However, I asked that they be available first thing in the morning tomorrow to address it.
All right, that sounds reasonable. So, Mr. Douglas, I have not had the opportunity to read that letter because of the other matters we had this morning.
Very well, Your Honor.
All right, but
so we'll take it up in the morning?
First thing.
Thank you.
Great.
Thank you, Your Honor.
All right. Anything else before we ask the jury to join us?
Well, it probably is. I think that just out of abundance of precaution, we should advise the court that after we finish this witness, I think before the next witness, Mr. Darden has indicated it'll be necessary to have perhaps a 402 hearing. He may have mentioned that to the court, so I wanted to let the court know that.
All right, who's the next witness?
Ron Ship, Your Honor.
Well, that's right. Okay.
So that may require a chamber conference before we
All right.
go on.
We'll start off with the hearing.
All right, I'm aware of the issue. All right, thank you. All right, Deputy Magnolis, have the jury, please. Reflect all the parties are again present before the court. Detective Farrell is on the witness stand. Detective Farrell, you're reminded you're still under oath. And Mr. Darden, do you wish to complete your direct examination?
No, I have no further questions at this time.
All right. Mr. Cochran.
Very kind of you. Good afternoon, Mr. Farrell.
Good afternoon, counsel.
You are presently assigned to the West Los Angeles Detective Division, is that correct?
That is not correct. I'm currently assigned to West Traffic Division.
All right. You formerly worked West Los Angeles Detectives.
Correct.
All right. And how long have you been in the West Los Angeles Division altogether?
Approximately 7 years.
And you're a sergeant, is that correct?
I am a detective.
Okay, and before that you worked as a sergeant?
I was a patrolman, training officer.
All right. And now you're working as a detective?
That is correct. I'm a detective supervisor.
All right. Now, in connection with this particular case, the matter was initially handled by an Officer Edwards, is that correct?
Correct.
And you had occasion to review his reports of January 1st, 1989, then you started handling the case as the detective, is that correct?
Yes.
And in that connection, you wrote some reports also, is that correct?
Yes.
And you shared with us that in the course of your investigation, you prepared a report. In that report, Mr. Simpson talked to you over the phone, is that correct?
Yes.
And what was the date of that? Was that January 3rd or thereabouts?
Yes.
All right, so the first time you talked to Mr. O.J. Simpson was January 3rd, and that was in this phone conversation when you called his house, is that right?
Correct.
His wife answered the phone,
That's correct.
and thereafter then you talked with him.
Correct.
Now, in that conversation, Mr. Simpson advised you that both he and his wife had been drinking after coming home from a party, is that correct?
Yes, that's what I recall.
And they had been, as far as you knew, to a New Year's Eve party, is that correct?
Yes.
Do you recall what time he indicated they came home from this party, sir?
No, I do not.
All right. And he told you that after that, after they come home from this party and had been drinking, a verbal dispute broke out.
Yes.
He told you that. And that he admitted that in this verbal dispute, there was a physical altercation that resulted in kind of a mutual wrestling type of altercation, is the words he used, right?
That's how he described it.
All right. And that he told you thereafter was that when he saw his wife, he was surprised to see a bump or a bruise on her forehead. Is that correct?
Correct.
And by the time that you had this conversation with Mr. Simpson, you, of course, had some Polaroid shots. Is that correct?
Yes.
Been taken. Do you recall how many pictures there were?
3.
And they were of Mr. Cole Brown Simpson?
Yes.
And with regard to the Polaroid camera, do you know, or was there such a camera at West Los Angeles Station during the early days of January of 1989?
I would assume so. I have never used one.
All right, you would assume there was, and I presume that would be something that would be owned by the city of Los Angeles. Is that correct? Camera.
That or the officer themselves own them.
All right. And as such, the film, if the city of Los Angeles owned such a Polaroid camera, the film would generally be also owned by the city of Los Angeles, right?
You can ask him if he knows.
If you know.
I would assume so.
Right. If the city of Los Angeles does have the wherewithal to buy film, don't they?
I hope so, yes.
Yes, and they did back in January of 1989, did they not?
I believe so, yes.
All right. This is in Orange County. We still have, we still,
Not yet.
not yet, so, not yet. We still have funds, right?
We may have a significant impact on this, Mr. Franklin.
Your Honor, then I better hurry up, so I don't want to cause any
I
further
think we
delay.
talked enough about
Right.
Polaroids.
At any rate, you're aware that there were facilities for taking pictures of individuals' injuries back in January of 1989 at West Los Angeles Station.
Not facilities that are designed to take photographs of injuries. We prefer to have the victim be transported to SID Photo Lab for proper photographic type things because they have better equipment, obviously.
I understand that, but I mean where you had a situation where someone was not transported to SID for photographs, you became aware that there was an ability at West Los Angeles Station to take photographs.
I assume that since I had 3 photographs given to me.
And you saw them. All right. Very well. Now, in your conversation of January the 3rd that we've been talking about, you spoke also with Nicole Brown Simpson. Is that correct?
Yes, I did.
And I presume, sir, that you had never met with or talked with either of these individuals, that is either Nicole Brown Simpson or O.J. Simpson, up to that point. Is that correct?
Yes.
Okay. And in her conversation with you, did she tell you what the...
Objection, Your Honor, to form the question.
May I finish the question, Your Honor? I'd like to finish the question.
Just asking if she said something.
I was going to phrase the question in a way that you might not find objectionable.
Well, I'll hear the question.
All right? That's what I want to try to do. In your conversation with Nicole Brown Simpson, was the subject matter broached of what the subject matter broached of what caused this argument between she and her husband in the early morning hours of January the 1st of 1989? And I said yes or no.
She did not give me details about what actually caused the argument.
All right, now let me get back to my question. Was the subject matter of that argument, the cause of that argument discussed, yes or no?
Not that I recall, not the subject matter of what caused the verbal dispute.
All right. Did you at any time have a conversation with Detective Edwards wherein he indicated to you whether or not he'd been told what the subject matter of that argument was?
Not that I recall.
And you never saw any reports, did you? Any of Detective Edwards' reports? The subject matter of the argument?
I read his follow-up report, which I requested. But subject matter of the actual fight, no, I don't recall seeing anything like that.
All right. So as you sit here now, even today, you don't really know what caused this altercation or confrontation. Is that correct, sir?
No, I do not.
All right, sir. Now, you then had occasion, I guess, after the January 3rd conversation, which was the first one, to have a second conversation with Mr. O.J. Simpson. Is that
Yes,
right?
I did.
And the second conversation was on or about January 5th, 1989. Is that correct?
Yes,
And in that conversation, Mr. O.J. Simpson contacted you. Is that correct?
that's correct. He called me out my desk.
And, of course, you recognize his voice again. Is that
Yep.
right?
Yes, I did.
And at that time, had you completed your investigation into this particular matter?
Well, as far as I'm concerned, I cleared the crime. I identified the individual who was responsible, and I believe I had enough to present to the city attorney's office to seek a prosecution.
All right, but as of the date January 5th, 1989, there'd been no determination made at that point whether or not the city attorney was going to file. Is that right?
Yes.
All right, and you so indicate that in your report?
Yes.
Okay. You completed your particular investigation, right?
Yes.
All right. And in this conversation that you had on January 5th, is this the conversation where Mr. Simpson voluntarily stated to you certain concerns and feelings that he had regarding this case?
Yes.
All right. Mr. Simpson told you, did he not, that he regretted the entire incident? Is that correct?
Yes.
That he was sorry that you, as a police officer, had to get involved in his personal problems?
Yes.
And he went on to claim responsibility and say that he knew what his conduct was wrong. Did he say that?
Yes, he did.
And he didn't mean to harm his wife, Nicole. He told you that, did he not?
Yes.
He went on to tell you that he planned to schedule both himself and Nicole Brown Simpson for counseling, did he not?
Yes.
And that he'd ask you to communicate that information to the city attorney's office when you took the case to them for filing or whatever. Isn't that correct?
Correct.
And in that conversation of January 5th, you told him at some point that you felt that at some point he had to stand up and admit responsibility for any actions that he'd taken on January 1st. Is that correct?
Yes.
And as the investigating officer, you are aware, are you not, that at some point thereafter, after January 5th, Mr. Simpson did, in fact, come into a court, enter a no contest plea, and resolve that matter. Isn't that correct? So
Overruled, he's the investigating officer. Do you know?
I never saw Mr. Simpson in court, ever.
all right. Well, you didn't see him in court, but you became aware, did you not, that the matter was resolved by way of a nolo contendere plea by Mr. O.J. Simpson. Is that
Yeah.
correct?
Yes.
And as the investigating officer, you knew that matter was resolved without a trial. Isn't that correct?
Yes.
All right. Now, let's back up for a moment. Prior to Mr. Simpson entering the no contest plea, did Mrs. Nicole Simpson seek to drop all charges against him?
When I first met her on the 4th,
What's the objection? Sure.
Carla, that's what we all do. I always sleep when I'm working. It's the best time to sleep. I can't wait to get there.
Questions overruled.
You got the question in mind? I can try to phrase it again. Certainly, sir. Prior to Mr. Simpson entering a plea to this misdemeanor charge of 273.5 PC, did Miss Nicole Brown Simpson indicate a desire to drop all charges against her husband and have a city attorney hearing?
Well, when I first met her on the 4th, she brought the kids with her, and I discussed what happens with these type of cases. And I wanted her input about her feelings towards prosecution. At that time, she said if she could avoid it, she doesn't want to prosecute. But I told her that no matter what she told me, even though she didn't want to prosecute, I'd have to take the case to the city attorney's office. Then I discussed some of the options that the city attorney may do, and one of those is the city attorney hearing. And then at that time, she said, well, I would like to have that. I think that would be neat.
All right, let me just back up. In your report, you spell it out. On January 4th, 89, you contacted Ms. Nicole Brown Simpson. At that time, she told you she did not want to prosecute, but would welcome a city attorney hearing. That's an informal hearing at the city attorney's office, right?
Correct.
You sit around with the city attorney and you discuss this matter, right?
Yes.
And so thereafter, you told her that the city attorney could make their own judgment. They may want to go forward with the charges whether or not she wanted to prosecute or not. Is that what you said?
That is correct.
All right. And ultimately,
Carla, quit your job.
we know that Mr. Simpson did enter this no contest plea to the misdemeanor charges, right?
Yes.
You were not in court that day, however.
Yes, I was.
All right. So you did see him enter the plea.
No, I never saw Mr. Simpson. I believe I went with with the city attorney, who was Rob Pringle at the time. I appeared at court that day, and I believe I stayed outside. They kept me outside in the hall.
Okay.
So they just told me what happened.
So you were in the hallway.
Yeah.
Okay. I understand. Now, just before the break, Mr. Darden was starting to ask you some questions about your investigation about other incidents involving Rockingham. And then we took a break. Is that correct?
Yes.
When you took the break, did you go up and talk to Mr. Darden about that?
No, we just went up to the office. I had a drink of water.
All right. He never asked you what the answer to the questions are going to be?
No, he did not.
He didn't say he was going to come back and not ask you those questions?
No, he did not.
What if I ask you those questions?
I'll answer them.
Do I want to hear the answers? I'll strike that. Now, at any rate, you, in the course of your investigation as one of the detectives, you told us just prior to the break that you had occasion to talk with some officers at that particular station. Is that correct?
That's correct. The city attorney asked me to look into possible other incidences up at the residence.
All right, so you talked to some officers. How many, just tell me a number, how many officers did you talk to altogether?
I can't recall, maybe 10.
And did you take any reports from any of those officers?
I requested, if they had any information, to write out a report and give it to me.
And you got a report from one officer, did you not?
That's correct.
And that officer's name is Mark Furman?
That is correct.
And was that the only written report that you received?
Yes.
And Mark Furman wrote you a report about an incident to which he'd allegedly responded at the Rockingham residence back in 1985. Is that correct?
He wrote a letter to the city attorney, yes.
And the letter he wrote in 1989 was referred back to an alleged incident in 1985. Is that correct?
Correct.
And would I be correct in assuming that that was the only letter that was sent to the city attorney in connection with the case of the January 1st, 1989?
That's correct. That's what I recall, yes.
And with regard to your search, did you search any records to see whether or not there were any radio calls to that location?
What the city, actually, the city attorney did.
I'm talking about you now, not
Oh,
the city
myself?
attorney. You, yes.
No, I did. All I did was contact the Communications Division of Los Angeles Police Department.
Do it.
So you did not check any records in West Los Angeles regarding possible calls that had taken place prior to January 1st, 1989?
I did my normal search of the computer.
All right? And you didn't find any calls, right?
None of them documented.
All right? And then by none of them documented, that means they weren't in the computer, right?
Police report.
All right? There were no police reports in the computer, right?
I couldn't find them.
All right? And you looked for them, and you were doing a diligent job, weren't you?
I tried.
All right. You were a responsible officer at that time, right?
Yes, I am.
Okay. And you're responsible today, aren't you?
Yes, I am.
Okay. You know how to use the computer?
Yes, I do.
Okay. You didn't find any police reports. And the only officer who stepped forward to write a report was this Mark Furman, right?
Yes.
And did you know Mark Furman prior to this particular time? I'll link it up.
He's been working West LA, and we all know each other at West LA.
So your answer is yes, you knew him?
Yes, I did know him.
All right. How did you happen to come to talk with him?
Well, he was one of the senior officers there. He was one of the officers that had most time there, and the city attorney asked me to look into the past 5 years, and he had been there at least 5 years.
All right. So when you told us about the talking to 10 senior officers, he would have been one of the 10 senior officers, is that right?
Yes.
All right. And then he then wrote this report. And was that report, the letter that he wrote around the middle of January of 1989, was that sent to you or to the city attorney?
I believe he gave me the original
Yes,
copy of
I've
it,
seen
and
those,
I
yes.
gave it to the city attorney's office.
And you're still in West Los Angeles now, are you not?
No, I am not.
And where are you now?
I'm at West Traffic Division.
All right. When did you leave the West Los Angeles division?
December of 1990.
You described when you were talking to Mr. Darden that your conversation with Mr. Simpson was a pleasant one, isn't that correct?
Phone conversation, yes.
Was it fairly common knowledge among West Los Angeles officers that on occasion some of them would in fact stop by Mr. O.J. Simpson's residence on a social basis?
I have no knowledge of that.
You had not done that yourself,
No, I have not.
but you don't know about any of the others, do you?
No.
But when you checked the computers for any other police reports or any other trips that officers had made out to the Rockingham resident after January 1st, 1989, you could not find any others after your diligent search. Is that right?
All I was looking for was
Before
documented
January
reports.
1st. And you could not find any
That is
documented
correct.
reports, right?
Not responses by police officers via the radio call, only documented reports, either by Mr. Simpson himself or Nicole.
Right.
I did not find any.
Okay, that was the question. I thank you very kindly, sir.
Mr. Darden?
The text indicated that the defendant fled in the contest and filed a battery charge.
That's correct.
He didn't plead guilty.
No contest.
And in fact, he struck a plea bargain in that case, didn't he?
Yes, with the court report, please.
We haven't heard from Miss Clark in a long time. I don't know, Nancy, some famous football player. This is live, or I would fast forward it.
All right, thank you, counsel. Mr. Darden, you may continue.
You also indicated that you had a pleasant telephone conversation with the defendant, detective,
Yes, I did.
but you weren't about to arrest him at that time, were you?
No?
Did you ask him why he fled the location on January 1, 1989?
Yes, I did. His response was that he was upset that the police were out there and weren't happy that the police were out there. And then that's when he decided to leave.
And you indicated to Mr. Cochran, and you told Mr. Cochran that you were only searching for documented reports. Is that
Correct.
correct? Okay, you were searching for documented reports in your search for other situations where the police went to Rockingham?
Yes.
There are other types of reports that officers fill out, is that correct?
Yes, there are.
They have logs, is that right?
Daily field activities reports. That's correct.
Okay. And what types of information would a patrol officer include on a daily field activity report?
That's speculation. I didn't need to further foundation. That question was...
No, I think he testified that he's been a patrol officer, was a training officer. I think he has sufficient foundation to answer what this is. Sufficient experience.
The report itself documents the time the radio car gets the call, its location, type of call, and when the call is finished and what the officer actually did at the location. And it's all documented in the officer's own writing.
And that daily field activity report is a report completely different from the report filled out by Detective Edwards, is that right?
That is correct.
What's the difference between the daily field activity report and the report filled out by Detective Edwards?
The follow-up report filled by Detective Edwards is a continuation of the crime report. The DFARs that we call it is just a daily log of activities that the officers does in the field. It's not part of a crime report or anything like that.
Are DFARs or daily field activity reports computerized?
Not that I know.
Were they computerized back in 1989?
I don't think so. They were not.
How many officers were there assigned to West LA Division back on January 1, 1989?
Quite a few. And an exact number I don't know. Over 100?
And is that 100 per shift or 100?
I wish it was 100 per shift, but it's maybe about 30 officers per shift.
30 patrol officers per shift.
Correct.
And each day, each patrol officer fills out a log?
If they are assigned by themselves, yes, but most officers in the Los Angeles Police Department are assigned A cars. That's 2 manned to each patrol car. 2 officers, I'm sorry.
So had you gone back and searched all the DFARs for the 5 years prior to 1989, that would have been quite a job, right?
That's correct.
Question, object to the form of that question.
Well, it's an innocuous point.
That would have been quite a job, right?
Yes, it would have.
And you would have had to have done a hand search.
Correct.
You also indicated that Nicole Brown asked that you not prosecute the case.
Yes.
You've had training in domestic violence, haven't you?
Yes, I have.
That's not uncommon, is it, for domestic violence victims to...
Sustained. Yes.
Do you think Kimberly Hurd actually had her own bunch of binders, or did she just steal all of Judge Ito's?
Sidebar with the court, please. All right, thank you, counsel. Mr. Darden, you may continue.
I'm sorry, was the objection sustained, Your Honor?
The objection is sustained pending a foundation.
Detective Farrell, what training, if any, have you had in domestic violence?
Basic academy training when I first came on the police department. Also in-service training with the Los Angeles Police Department on domestic violence.
Plus, I'm a police officer in Los Angeles, so I have plenty of home experience.
And did you take a course?
Yes, I did.
And how many hours?
It was a 3-day in-service training for advanced field officers, which I believe totaled a 24-hour course.
And have you responded to domestic violence calls in the past?
Yes, I have.
Many?
Quite a few, yes, sir.
How many would you say?
I could only say hundreds.
And have you been the investigating officer on domestic violence cases in the past?
Yes, I have.
And have you participated in the prosecution of domestic violence cases in the past?
Yes, I have.
Have you read literature having to do with domestic violence?
Yes, I have.
Have you read literature having to do with the causes and effects of domestic violence?
Yes, I have.
Have you spoken to victims of domestic violence?
Yes, I have.
And have you watched them testify?
Yes.
Have you spoken to others who are professionals and who are experts in the area of domestic violence?
Yes, I have.
And have you ever testified in court as an expert on domestic violence?
I have never testified as an expert.
Thank you, Your Honor. Nothing further.
Any recross?
Yes, Your Honor, just a couple questions.
Secretary Farrell, when you were asked by the city attorney to try and determine whether or not there had been other calls in the 5 years or so that preceded January 1st, 1989, did they give you kind of a blanket instruction to do the best that you could?
Yes.
And you, in the course of trying to carry out their request, you did the best that you could, did you not?
Yes.
And then you then reported back to them after you had done the best that you could. Is that correct?
Yes, I did.
And in doing the best that you could, you got this one letter from Mark Furman. Is that correct?
Yes.
Thank you very kindly. I have nothing further.
Mr. Darden?
Nothing further, Your Honor.
All right. All right, Detective, thank you very much. I'm going to excuse you from further testimony. Please don't discuss your testimony with anybody else except for the attorneys in the case.
Thank you, Your Honor.
All right, thank you very much. All right, Mr. Darden, as to the people's next witness.
Your Honor, before we call the next witness, I have in my hand here what appears to be a Xerox copy of a single-page letter. It is dated January 18, 1989. It was directed to the city attorney for the city of Los Angeles, and it is signed by Detective Mark Furman. May it be marked People 7, identification.
People 7. All right. Mr. Darden, how do you wish to proceed at this point?
I think we should resolve the preliminary legal issue that we have to resolve.
All right. Ladies and gentlemen, I have a legal issue that I need to resolve before the next witness can
Bye,
be presented.
Corn.
And given the lateness of the hour this afternoon, I'm going to recess as far as you were concerned this afternoon. Please remember my admonition to you. Don't discuss the case amongst yourselves, form any opinions about the case. Don't allow anybody to talk to you about the case. And you are not to perform any deliberations till the matter has been submitted to you. Have a pleasant evening. We'll see you back here tomorrow morning, 9 o'clock, and we'll have more witnesses for you. All right, see you tomorrow. All right, I'm going to ask counsel to remain.
Suggests that Mr. Simpson and Mr. Shipp had a conversation about some sort of a polygraph or the taking of a polygraph. There are allegations in a book about which I'm aware that suggests that Mr. Simpson discussed some sort of a dream with Mr. Shipp. Is it possible you're on the new way approach to continue the remaining areas of concern?
I don't see the necessity for that except to conceal the issue before the court, Your Honor. And the issue is going to be in front of the jury, so we may as well do it in the open.
Well, that's what the hearing's about. How does he know that?
Well, Mr. Douglas gets to answer
Yes.
his argument for himself.
I would have loved it. I think I would have
All
loved
right,
it.
with report, please. All right, back on the record. Mr. Cochran,
Yes, Your Honor.
have you had the opportunity to talk to your client about Ronald Ship?
Yes, I have, Your Honor. He has been aware of it for some time, so he's aware of that. And maybe I should just state for the record
Certainly,
the
please.
situation.
Your Honor, I understand that the next people's witness is Mr. Ronald Ship. And Mr. Ship is related to me. He's a cousin. His father is the father of my cousins. He has a different mother. And I've shared that with Mr. Simpson, and as such, there's a potential conflict, but I've shared it with Mr. Simpson, and he waives that conflict.
If she's in the bathroom for less than 2 minutes, she doesn't have to. Any longer than that, it goes with her.
Because of the potential relationship, I will not question this particular witness, however.
All right. Mr. Simpson, is this agreeable to you that you have no objection to Mr. Cochran remaining as your counsel, despite the fact the prosecution will be calling a relative of his as a witness?
No problem.
Great, thank you. All right, counsel, you've broached to me a interesting legal issue that I had no idea was coming again. Thank you. We're within 10 minutes of the close of the business day in any event. Counsel, if you have any cases on the issue, please fax them to the court. I'll pick them up first thing tomorrow morning. I'll be in the building for a while too. Anything else? All right, if you'll provide that, that'll be the standing order. All right, anything else, counsel?
What time do we adjourn tomorrow?
9 o'clock.
Adjourn, is it 4 o'clock or 3:30 on Wednesday?
4 o'clock tomorrow. I'm sorry? That was the day the juror had to go to the doctor's appointment that created the other problem for us. All right, we'll stand in recess till 9 o'clock. Ms. Abramson, can I see you, please?
Please clear the courtroom.
Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey, people represented by Ms. Clark and Mr. Goldberg. And we had a preliminary matter to settle before calling the next people's witness in the nature of an objection regarding certain content of the statement. We're now joined by Mr. Darden. Good morning, counsel. All right, Mr. Douglas, I've reviewed the Estes case, 82 Calap 3rd, 509, Estes, E-S-T-E-S. And I've also reviewed the memorandum of points and authorities filed this morning by the prosecution and specifically by Ms. Lewis.
Your Honor, this morning we found a couple of additional cases that we wanted to cite to the court and counsel. I apologize for not having them in the points and authorities. One was People versus Bowe at 1 Cal 4th, 281, and the relevant discussion starts on 302. And the other case is also a California Supreme Court case. People versus Pride at 3 Cal 4th, 195. Relevant discussion starts on 234.
Regrettably, Your Honor, I've only this morning had a chance to briefly peruse the memorandum that was submitted. I have not, of course, had a chance to review these cases or their applicability to the issue at hand. I expect that my cross-examination of this witness is going to last for at least a couple of hours. I would like, before I am required to respond with any in-depth analysis, to at least be given the chance to review these cases, to examine them. I believe, Your Honor, that the statute about which we concern ourselves is clear. I offered a parallel to that statute in the Estes case, though it is not the exact statute. I do think that the reasoning of that statute is very applicable to the issue at hand. I do think, Your Honor, that there's another threshold issue that is raised, and that is one of 352, as to the probative nature of the substantive statement, even in any excised form. I think that there is a tremendous question in the scientific community as to the predictive nature of certain statements about which we concern ourselves. They are not predictive of events that may have occurred in the past or predictive of things in the future, and that entire issue is one that is most properly the subject of expert testimony. There is the very strong likelihood that it is going to necessitate confusing of issues, the undue use of additional time, the certain calling of different witnesses who might be experts on this area, who might then be able to place these statements, even in its excised form, in a greater understandable context for the jury. I offer to the court my opinions, as I did at sidebar, that I cannot properly address the circumstances in which the statement was allegedly given, and for the record, we will deny that the statement was even made, and we will strongly challenge the factual predicate for the giving of the statement, such that we would think it proper that there be a hearing consistent with Evidence Code 403, laying the foundation for the preliminary fact that, in fact, this statement was even given. For all these reasons, Your Honor, and given the fact that I have not had an adequate chance to properly cross-examine or to properly review these cases, that we be allowed to examine this witness, because I'm ready to examine this witness on matters other than this disputed area, that I be given adequate time to do my own independent research given this new information, and that the witness be recalled later in the trial, or that that portion of his testimony be held until later.
Mr. Goldberg? Mrs. Robertson, let me ask you to, if you would, make 2 photocopies of the relevant portions. Thank you.
Your Honor, apparently the defense has been aware of the statement since January the 22nd, and obviously if there were any issues as to legal admissibility, there was plenty of time to research those, to address those today. Obviously, the prosecution wants to put the statement on as part of Mr. Shipp's testimony. There's no reason for breaking up his testimony and having him come back later after counsel has had an opportunity to do further legal research. Does the court want the prosecution to address our theory of admissibility now and the issues regarding the statement?
Yes.
Okay. I'd first like to start out with a discussion of the relevancy of the statement, because I think counsel seems to be suggesting under 352 it's not admissible. And any discussion probably should start with an issue of why is it probative, why is it relevant? And then I'll get into the issue of the polygraph aspect of the statement in the second part of my response. As to the probative value of the statement, Your Honor has ruled already in the context of the domestic violence evidence that the prosecution is entitled to put on evidence in this case, and apparently spend a significant amount of time doing so in what I think the court characterized as being the equivalent of several misdemeanor jury trials. We are entitled to put on this evidence for the purposes of showing the defendant's mental state and showing his intention at or around the time of the murder.
But the controverted statement, though, is the very next day. So, I mean, we're out of the category of domestic violence, wouldn't you say?
I just want to tie it into why it is relevant in the context of all of the evidence that the court has allowed. The purpose of that evidence is to allow the jury to infer something circumstantially about what the defendant was thinking at or around the time of the murder, what his mental state and his motivations were. It's circumstantial evidence because the inference, the chain of inferences, is that we can determine from his conduct what his intention, what his mental state must have been. The evidence pertaining to Mr. Shipp differs in only one respect, and that is that instead of being circumstantial evidence of his intent and his mental state, it's direct evidence, because it's him saying, this is what I've been thinking, and from the context of the statement, it was over a period of time. Now, the distinction there between direct and circumstantial isn't particularly important. What I would suggest to the court is important is the way that the respective sides have asked the jury and this court to interpret the circumstantial evidence. Because what we've said, Your Honors, we've said, look, what this evidence shows is it shows that the defendant had an obsession with Nicole Simpson, and that it was an obsession that led to her murder. I guess what we could term a fatal obsession. Isn't that precisely what the statement to Mr. Shipp is saying? I have been dreaming about killing my wife. Isn't that powerful, powerful evidence of that fatal obsession, except that instead of coming in the form of circumstantial evidence, it's coming in the form of direct evidence. The defense, on the other hand, has a different interpretation of the domestic violence evidence. They say, no, it's not really evidence that shows the defendant's state of mind in terms of a fatal obsession. What it really shows is a cycle of benevolence. And they're entitled to make that argument, Your Honor. We're not saying that that is improper. That is a proper jury argument. But when they are allowed to stand before the jury and say that all the circumstantial evidence that the prosecution has introduced simply shows a cycle of benevolence, and we have direct evidence which conclusively shows that that isn't true,
Well,
that he really...
Let's sort of leap ahead to what really concerns me, because
Okay.
I agree with you that it's an interesting statement. Were I in your shoes, I would probably want to get it before the jury. What concerns me about this is two things. One, the 351.5 prohibition of any mention of polygraph or lie detector, which is included in the context of this statement. And secondly, whether or not it's fair or somehow fundamentally misleading to the trier of fact to pluck this sentence out of the context in which it was said, which is beginning and ending with comments about polygraph. So is it fair to pluck this out? That's the concern that I have.
Okay.
Mr. Goldberg.
Thank you.
I mean, that's the issue that I see. Assuming you get over the relevance question, assuming I agree with you that it has some probative value and would be of interest to the prosecution case, and that it clearly is virtually contemporaneous to the acts in question.
Yeah,
What concerns me is the context.
Okay. Yeah, I suspected that, Your Honor, that is where the court's focus was
So
going to be.
why don't we jump to that?
Okay. But let me just point out, the only reason that I was talking about relevancy and probative value is that there's a spillover effect on this question that the court's concerned of can you sever part of the statement out and then leave the portion about the defendant dreaming about killing his wife, and is that fair?
Well, Mr. Goldberg, let me ask you this, because yesterday in the discussions that I had, nobody gave me a precise offer as to exactly what statements were going to be offered.
Okay, let me read the entirety of the statement, including the portions that I believe the court finds to be objectionable, as well as those the prosecution wants to introduce. Excuse me?
Go ahead.
Thank you. I was interviewed by detectives, and they asked me to take a lie detector test. And I replied, well, what did you say? This is Mr. Shipp talking. And he kind of chuckled and he says, "Hey, to be truthful, Ron, man, I've had a lot of dreams about killing her." And he says, "I really don't know about taking that thing." He did not say he wouldn't take it. He says, "I really don't know about taking it." So that is the full context of Mr. Shipp's statement to us. The portion that we want to introduce is merely the portion that says, "Hey, to be truthful, Ron, man, I've had a lot of dreams about killing her," unquote. That's the portion that we're interested in. But to get back to the issue that the court addressed, the reason that I made some comments about relevancy is that in our state, under our Constitution, Article 1, Section 28, we do have a right to truth and evidence in the state. And there are only certain specified exceptions to that right. And those exceptions are that a statement can be excluded. The statement can be excluded, or evidence can be excluded if it's privileged, which this isn't, if it's hearsay, which this isn't, if it's 352, which this isn't, if it's protected by the rape shield law that's codified in 1103 and 782, which this isn't, or if it's taken in violation of the federal Constitution, which it isn't. And that's what the Constitution says of our state. It shall be admitted. This is highly relevant evidence, and it doesn't come under any of the exceptions, and therefore should be admitted. Let me just point out that as to the statement, that the context of the statement was relating to the police interrogation. Just to put the quoted portion in context, Your Honor. He was talking about his conversations with the police in the context of making the statement that I previously quoted. Therefore, the issue becomes, Your Honor, are we somehow going to, contrary to the clear policy of the right to truth and evidence provision, exclude highly probative evidence, evidence which really seems to blow a hole in the defense theory of a cycle of benevolence, simply because contained within that statement there are other materials that Your Honor is rightfully concerned about, which are inadmissible. And clearly the law of the state does not lead us to what in our view would be an absurd conclusion. I'd like to get...
OJ spoke to someone and said, they asked me to take a polygraph, but I don't know if I want to take a polygraph because I've dreamt many times about killing her.
Get into that legal issue now, which is, I think, what is at the forefront of the court's concern. And starting with Evidence Code Section 356, which I believe is a section that's relied on by counsel, which, like Evidence Code Section 352, I think has been oversimplified again and again by attorneys and misstated by attorneys in terms of what it really stands for. The court may recall that when we addressed 352 last, I pointed out that oftentimes attorneys talk about something being more prejudicial than probative, and they cut out that word substantially more prejudicial than probative. Over and over again in our courts, we see attorneys saying, well, Your Honor, if they put in part of the statement, I get to put in the whole statement. I think Your Honor's probably heard that. And that is not the law of the state of California. It never has been, yet it's continuously repeated as if it were handed down by Moses from the Mount. It is not what Evidence Code Section 356 says. It's not what the cases say that interpret that statute. What the statute stands for is the very common sense proposition that when you put in part of a statement and the other side can demonstrate that it is necessary to put in another part of that statement, to put it in context, that can be allowed. And there are a number of cases that interpret 356 in that way, one of which we cited in our brief, the other two which I provided this morning. One being People versus Bowe, that was at 1 Cal 4th, 281. And what it says of Evidence Code Section 356 is, quote, the section permits introduction only of statements on the same subject or which are necessary for the understanding of the statement already introduced. The other conversation referred to in the Evidence Code Section 356 must have some bearing upon or connection with the admissions or declaration in evidence. So in other words, when we need it to put something in context, then we can use Evidence Code Section 356 to do that. I think the case of People versus Pride is more instructive for Your Honor. And there what happened at 3 Cal 4th, 195, is the defendant gave a very lengthy tape-recorded interview to the police that occurred over a course of approximately 2 hours. And instead of introducing the tape recording, what the prosecution did is they called the detective that took the statement to the stand, and they asked him about only one tiny little snippet of that conversation. That was a statement to the effect that the defendant accounted for his whereabouts, and those whereabouts were false. So the prosecution simply wanted to prove that in a couple sentences of that lengthy interview, he had made a false statement. And the defense says, well, we want to put in the whole thing. We want to put in the whole thing to show that maybe the defendant's state of mind was such that he was confused or wasn't really focusing in on what the detective was asking him. We want to put it in maybe to show that he was giving an estimation or an approximation in accounting for his whereabouts as opposed to a definitive type statement. Trial court there did not allow it in. And what the California Supreme Court held was that it was properly excluded because they reviewed the tape themselves and they found that it would have been an abuse of discretion to admit the rest of the tape because it did not support the defendant's theory that there was psychological coercion. It did not help to explain or account for the statement. And in fact, the tape amply supported the prosecution's theory that the defendant gave a positive accounting for his time, which turned out to be false. So they held that if the court had admitted it, it would have been an error. So I think that very, very strongly supports what the prosecution is asking Your Honor to do here. Now let's take a look back at the defendant's statement to Mr. Shipp. The quote being, "Hey, to be truthful, Ron, man, I've had a lot of dreams about killing her." In and of itself, the statement is perfectly understandable. It is perfectly clear. It's the defendant saying, I've dreamed about killing this woman. It's very simple, very straightforward. What is the statement that immediately preceded that? I was interviewed by the detectives and they asked me to take a lie detector test. And then he chuckles. How does that possibly put any different spin on the statement? It doesn't explain the statement, qualify the statement, retract the statement. It doesn't do anything to make the statement more understandable. How does the fact that he says, I was offered to take a lie detector test, either contribute or detract from the statement that he was dreaming about killing his wife? Does it make it more likely that he was dreaming about killing his wife or less likely? I'd submit to you that it is logically entirely irrelevant.
Okay, guys, we hit right up against 8 o'clock again. My bad. We did it. We did good. I like this. I hope they can get it in, but my guess is they're not going to be able to get this in. Oh, I wish they could get this in, though. But I think all of us have said that at some point. I dreamt about killing my husband. I dreamt about killing my wife. When they leave their socks, when they don't do the dishes, when So, maybe the jury will think about that and be like, yeah, I've done that about my wife a million times. Anyway, I hope they can get it in, though. I can't wait what Cochran's going to say to this 12-year-old kid when he gets up. All right, guys. Thank you so much. I will see you again really, 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 really soon. I hope you guys have the best day. Bye, guys.